Good day, sir. This is the summary of the discussion on Roe versus Wade last March 7, 2026. The discussion started with Professor Fitzpatrick asking the question on what was the prevailing law in the state of Texas prior the Roe versus Wade issue on abortion. Ms. Abrenica said that the Texas Penal Code then prohibited abortion. Ms. Verdida added that it is indeed prohibited except for medical reasons on saving the life of the mother. Professor Fitzpatrick posed the question on whether merely taking a morning pill to stop possible pregnancy is already prohibited under the Texas law. The same was answered in the affirmative. Ms. Verdida discussed the three consolidated petitioners in the case of Roe versus Wade. First is Roe, who wanted to abort her baby. Second is the couple who must avoid pregnancy as it poses threat to the health of the wife. And third is the doctor who was previously arrested due to violation of the Texas Penal Code. And he invoked the right to doctor-patient privacy. Professor Fitzpatrick then asked the class how the case of Roe versus Wade reached the Supreme Court. Referring back to the structure of the court Professor Fitzpatrick earlier presented, I answered that the case was a consolidated case in the U.S. District Courts, which skipped the appellate court due to the declaration of the said law as unconstitutional. Mr. Neil Balili discussed that the court considered two main justifications for the Texas law. First is the protection of maternal health, and second is to safeguard the well-being of the fetus. It discarded the proposition that it prohibits illicit sexual affairs, which was considered a Victorian concept. Ms. Juralyn Obra discussed the compelling interest test, which means an extremely important government objective that justifies or limits a fundamental constitutional right. Thus, abortion restrictions are valid only if the state proves compelling reasons. Accordingly, there is no compelling state interest in the first trimester. Professor Fitzpatrick discussed state interest versus right in relation to the case of Loving versus Virginia on interracial marriage. He likewise discussed substantive right, as stated in the 14th Amendment, on the right of the government to pass a law, and relate this to the case of Skinner versus Oklahoma as regards sterilizing prisoners. Thereafter, Mr. John Sagaban discussed the case of Griswold versus Connecticut, which is the immediate predecessor of Roe versus Wade. It's called the immediate predecessor because it was the first time the U.S. Supreme Court explicitly found a right to privacy hidden within the Constitution. According to him, the same was promulgated in 1965, and it established the right to privacy for married couples to use birth control methods. Professor Fitzpatrick called this as one right creating another right. Mr. Neil Balili then mentioned that the argument of Roe is that women have an absolute right to terminate pregnancy. On the other hand, Texas State argued on the protection of prenatal and the health of the mother. Miss Christine Abrenica then discussed the concept of trimester as enunciated in the case of Roe versus Wade. Professor Fitzpatrick said that in the first trimester, the court allowed absolute abortion because fetus has no life viability. Ms. Abrenica continued and stated that in the second trimester, the state can regulate abortion if only to protect the health of the mother, and on the third trimester, the state can totally prohibit abortion due to the life viability of the fetus. Professor Fitzpatrick then summed up the discussion by directing the class to page 152 of the decision on Roe versus Wade as regards the fact that the U.S. Constitution never mentioned explicitly any right of privacy, and yet the court or the individual justices found that the roots of the right of privacy can be found in the following: First Amendment, Fourth and Fifth Amendments, penumbras in the Bill of Rights, Ninth Amendment, and in the concept of liberty as guaranteed by the first section of the 14th Amendment. Accordingly, the right extended to activities relating to marriage as ruled in Loving versus Virginia, procreation as stated in Skinner versus Oklahoma, and contraception, as well as family relations and pregnancy. Professor Fitzpatrick likewise said that the right to abort pregnancy is not unqualified, and state interest for regulation must be considered. He then directed the class to read the last paragraph of the page 155 of the decision on the need to limit the said right when there is a compelling interest, and for the legislative to narrow it to legitimate state interest. However, interestingly, in this case, the court did not stop there and continued by promulgating the concept of trimester. After the discussion, the dissenting opinion of Justice Rehnquist was discussed by Mr. P.J. Montances, wherein, according to Rehnquist, during the promulgation of the case, there was no potential life that the state needs to protect, as the petitioner wrote then already gave birth. Second, the decision is an act of judicial legislation referring to the trimester concept, and that the right to privacy has no historical basis in the Constitution. Professor Fitzpatrick then said that there was only a hypothetical pregnancy in that case, as only pregnant people in the first trimester can only file the case. The court should have applied the rational interest test to determine if the law is constitutional and not the strict scrutiny test. Lastly, Professor Fitzpatrick mentioned about the right to privacy being unknown to the drafters of the Constitution when they rationalized the 14th Amendment then, thus a violation of historical originalism. My take in this case is the decision in Roe versus Wade made a bandwagon effect to the other Supreme Courts in the world to decide rights which are not written in their constitution and are only presumed to be there. This case also initiated the role of judicial activism in court to the point of making judicial legislation on rights never intended by the legislative branch of the government or the framers of the Constitution, as the case may be. That's all, and thank you, Prof, for giving me the opportunity to make a summary and conclusion on the Roe versus Wade case which we discussed last meeting.